Well, just point out a couple of things. If you look at the correspondence, again, what is public record in this case? The state has very clearly indicated to us that next generation technology has to go beyond what the current standards are. So we cannot set 7-to-1 as the bar for the next generation technology for odor control. So what we do with these measurements that have been taken, and there is receptors, as your first question, we are trying to determine what the odor reduction would be such that it would have an impact at the receptor. And we want that impact at the receptor to be essentially on a generic scale, I'm not talking about logarithms, to be a very faint odor. And the last point that I'll make is we are very open to looking at findings and validated research. And if you go into the very most recent minutes that have been released and motions from this team, you will see that that 80% has actually been changed to 70%.
Great.
So it's part of the process. It's part of the process. It's part of the learning curve. It is very, very challenging and very difficult. We hear what you and the others say.
Just a couple of things I follow up on this, Boxley. First of all, the first question that you asked was, has the panel conducted any scientific testing at a PSF property or a neighboring property from PSF where we've installed low trajectory technology with lagoon covers and an A&D system? Right. The Iowa State survey was done around the Locust Ridge farm in 2006. Locust Ridge is one of the last farms on the schedule to receive next generation technology. We will install an A&D. We have not today installed an A&D system at the Locust Ridge farm. So just wanted to clarify that. And then again, reading from the consent decree, from the 1999 consent decree, the definition for next generation technology in the state is, the phase next generation technology shall mean an improved waste handling and storage system designed to reduce or eliminate the release or threatened release, discharge or emission of contaminants, odor, and or pollutants from all operations to the fullest possible extent, consistent with the following commitment. That's what Mr. Williams put up on the screen. And then he shared with you some things that former director, Deputy Director Bill Bryant, that he interpreted and added to that at a later date, again not in the consent decree. But the actual language of the consent decree goes on to read, consistent with both federal and Missouri water pollution control laws and related regulations. 7-to-1 dilution threshold is Missouri law. I think that's what the consent decree says.
Thank you.
It is 9:36. We have about 18 speakers left that have asked to speak. So, with your permission, we'll proceed, but maybe at a more rapid pace so we can get to our elected officials. Is that okay? Is that how you'd like to do it? Since the elected officials are representatives of their community, I was going to give them the opportunity to ask questions before the end. So, if you don't mind, that's what I'd like to do. And whether they ask if they have something or not, I don't know. Hey, let's do this. Mr. Hinkey is here. Let's let Mr. Hinkey speak, and then we'll take questions from the elected officials. Is that okay? Certainly. Yeah. Thank you. Thank you.
My name is Mike Hinkey. I'm a contract producer in northeast Mercer County. My sons, their family, my brother and his family, all our livelihood is based on contract farms. So I have a question, maybe directed to Jack in particular. We're concerned to see how the lawsuits proceed on against PSF. If we follow our permits, our nutrient plan,
I don't think I can necessarily give a yes or no question. What I can tell you is
it is a yes or no question. If we follow all the regulations set up by the state and the federal government, are we going to be subject to nuisance lawsuits?
okay. And you want to know if following the permit, following all the permits and the federal laws guarantees that you will not be found, that no one can sue you for a nuisance. And
Right, that is the question.
okay, now I understand. Quite honestly, my understanding of it is no, it's not a guarantee, and I can't make that assurance to you.
Okay. Then I have just a general statement, I guess, addressed to everyone. As we see how the lawsuits proceed on against PSF, I think we all understand the agenda by this law firm. Then we would expect as contractors to be the next target. Is there anything that we're going to be able to do to prevent that? Will we get any support from our state government and our ag officials, or do the decisions that this panel makes directly impact us all? You know, they've already said they live 1,000 miles away or more, so it's really not going to affect them personally, only those of us that live here. I think it might be important, too, for everybody to know that the same law firm that is suing PSF, you know, sometimes the corporate image carries a bad name, and it's easy to focus on corporate images, corporate business. But I have an acquaintance and a friend that has a forever finish operation, father and sons in Southwest Missouri, Bill Howard, and he's being sued by the same group of attorneys that are suing PSF. So I think everybody in the room should be aware that whether you're a hog producer or a dairy producer or a cattle producer, that, you know, we're all being targeted by this group. I think the decisions that could be made by this group here could have an effect on that. And, I think they might want to consider that in some way.
And if you could just summarize that question you asked very quickly so that I'm sure I understand it. Because you made a statement, you finished up with a statement, but you had a question before that.
Well, my question was, I guess these folks have a chance to make decisions that affect all of us. And will they, or are they going to?
The decisions that we make are going to be consistent with the process that has been described this evening and the interpretation of the consent agreement. I now am only speaking for myself. I don't think that I can be influenced by what happens in lawsuits, whether they go for the plaintiff or the defendant relative to the terms and conditions of the consent judgment. I feel like our responsibility and our appointment is consistent with the terms and conditions of that consent judgment. If the state and the parties agree to modifications, we're not making the rules in that. We are open to continual interpretation, continual modification, if the parties to the agreement go that route. That is why we have continually asked for that type of input from the state and the parties to the agreement.